Hey yo, thanks for tuning in to The Source, your source for celebrity news. Check this out, because we've got an update on the Lisa Gardner versus Sean P. Diddy Combs case. Lisa Gardner is the Caucasian female who accused P. Diddy and Aaron Hall of taking turns abusing her and a friend when she was 16 in 1990, after they were all introduced while attending a dinner with Jodeci in New York City. Gardner alleges that even though she had not yet met the legal age to drink, which is 21, she was offered alcohol, and then both Sean P. Diddy Combs and Aaron Hall invited her and her friend back to Aaron Hall's apartment for what they called the after party. And we all know how that goes, because like R. Kelly said, after the show is the after party, then after the party is the hotel lobby, and after the Belv then it's probably Chris, and after the original is probably this. I tell you, these dudes were just giving away their whole blueprint in their lyrics. Anyhow, Gardner claims that when she went to Aaron Hall's apartment, they offered her more to drink, and she was physically forced to have relations with Sean P. Diddy Combs against her will. In her complaint, Gardner also said that after Diddy finished doing his business, she laid in bed shocked and traumatized. However, as she was in the process of getting dressed, Aaron Hall barged into the room, pinned her down, and similar to Diddy, forced her to have relations with him too. You know what's crazy about this whole thing? I have been in a room alone with Aaron Hall before, and I gotta tell you, I'm starting to feel very lucky that nothing ever happened. And no, I was not trying to get with Aaron Hall. He was dating an associate of mine, and the most that I ever did with that dude was play spades. Well, anyway, in her complaint, Gardner's attorney, Tyrone Blackburn, who also represents Diddy's other accuser, Little Rod, and Christian Combs' new accuser, who says that Christian tried to drug her and assault her on a boat, also filed suit against UMGR, which stands for Universal Music Group. Tyrone Blackburn alleges that UMGR are basically co-conspirators because they enable Sean P. Diddy Combs to commit all of his alleged crimes. However, despite all of the allegations that Tyrone Blackburn is making on behalf of his client, on April 11th, UMGR's attorney filed a motion to dismiss the case against them, citing that not only is Tyrone Blackburn an inept attorney who has a history of filing frivolous lawsuits in the wrong jurisdictions, but the attorneys representing UMGR also claim that Tyrone Blackburn failed to serve UMGR with a true copy of the summons and first amended complaint in the Gardner versus Combs case. Although Tyrone Blackburn insists that he followed all the proper protocols and even submitted an affidavit to the courts on March 22nd, 2024, stating under oath that a summons was in fact delivered on the plaintiff Lisa Gardner's behalf to someone at UMGR's office named Diana Ruiz, who the server described as a 5'4" Hispanic woman who was approximately 25 years of age, 140 pounds with black hair. UMGR insists that Tyrone Blackburn could not have possibly served any legal documents to someone named Diana Ruiz because no one named Diana Ruiz is employed by them or any of their offices. Yo, who in the world did Tyrone Blackburn give these darn papers to? As a result of what they claim to be Tyrone Blackburn's failure to meet his obligations as an attorney, UMGR's attorneys, led by Lisa A. Linsky, filed a motion to dismiss the claim on April 11th. And UMGR's motion, which was submitted on behalf of their law firm, McDermott, Will & Emery, LLP, Lisa Linsky states, defending UMG Recordings Incorporated incorrectly sued herein as MCA Incorporated, MCA Music Entertainment Group, Geffen Records, and Universal Music Group MV, collectively referred to herein as UMGR. 1. Respectfully submits this memorandum of law in support of its motion to dismiss the first amended complaint of plaintiff Lisa Gardner pursuant to CPLR 3211 A5, 7, and 8. Alright, so now, if we scroll down to the preliminary statement, UMGR's attorneys wrote, plaintiff alleges that she was sexually assaulted in 1990 by defendants Sean Combs and Aaron Hall during a trip to New York City. The complaint's allegations, if true, are certainly disturbing, but even assuming plaintiff's complaints were timely, which they are not, they have nothing to do with UMGR, in particular as set forth herein. Plaintiffs' claims against UMGR must be dismissed because they are 1. Entirely time-barred, 2. Not cognizable as against UMGR, and 3. Otherwise deficient as a matter of law due to the complaint's absence of any factual support connecting UMGR to the alleged assaults. First, the complaint primarily relies on CPLR 214J, known as the Adult Survivors Act. the ASA, which revived otherwise time-barred claims arising out of certain sexual offenses provided they were filed by November 24, 2023. Notably, and fatal to the plaintiff's complaint against UMGR, the ASA only revived time-barred claims alleging sexual offenses that occurred while the plaintiff was over the age of 18. Here, plaintiff repeatedly admits throughout her complaint that she was only 16 in 1990 when the alleged sexual assaults occurred, thus rendering the ASA inapplicable and all claims time-barred. Although plaintiff could have brought her claims under the related revival statute CPLR 214G, the Child Victim Act CVA, plaintiff failed to do so by August 14, 2021, when the CVA's 2-year revival window closed. Accordingly, plaintiff cannot rely on either the ASA or CVA to revive her claims, and they may remain time-barred. Alright, so this right here is very interesting because UMGR is arguing that like Tyrone Blackburn filed under the wrong statute, and now the time has run out to file under the right statute, so they gotta dismiss the case. And here's the thing, if the judge agrees with UMGR and they agree that Tyrone Blackburn filed under the wrong statute because he should have filed under the CVA instead of filing under the ASA, then they're gonna have to turn around and dismiss the case. And if they dismiss this case for UMGR for that reason, then they're ultimately going to have to turn around and dismiss the case when it comes to both Diddy and Aaron Hall. Alright, so after I read that, I went and looked up the law and looked at section 214J, and guess what? It does say that the law is only applicable to people who are 18 years of age or older at the time when the crime was committed. So, based on this argument, it looks like Universal Music Group has actually found a very good reason for this case to be dismissed. And you best believe that if Universal Music Group gets this case dismissed, then Aaron Hall and P. Diddy are going to piggyback on their legal strategy and use the same exact argument to get the case dismissed against them too. Alright, so then, the attorneys continue on to say, second, even if the plaintiff could bring claims under the ASA or CVA, which she cannot, plaintiff fails to allege facts that support any theory of liability by UMGR for assault, battery, or negligent infliction of emotional distress, NIED. Plaintiff makes no allegations supporting vicarious liability for battery or assault, nor could she. Plaintiff's NIED claim also fails because she has not alleged any duty owed to her by UMGR, and nowhere in plaintiff's complaint does she allege that UMGR's conduct was extreme and outrageous, as she is required to do so in a matter of legal sufficiency. I don't know about this particular argument because I think it depends on who was hosting the dinner party. If Jodeci was throwing a dinner party by themselves and UMG didn't know anything about it, then of course they don't have anything to do with that. However, if they were hosting the party on behalf of their artist Jodeci, then yes, they can be held accountable when a 16-year-old girl gets into that party and she's being plied with a whole bunch of drinks, and then she gets so inebriated that she ends up going home with P. Diddy and Aaron Hall. Because there's this simple thing, and it's called checking IDs, people. Checking IDs. Alright, back to the motion to dismiss. Third, plaintiff's claim under New York City Administration Code 10-1101, known as the New York City Victims Agenda Motivated Violence Protection Law, GMVL, fails as a matter of law because GMVL was not in effect in 1990 when the alleged sexual assaults occurred, and the GMVL cannot be applied retroactively. Even if the GMVL did apply retroactively, plaintiff failed to state a claim against UMGR under the statute because the complaint is devoid of any allegations demonstrating that UMGR enabled the misconduct of defendants Combs or Hall. Finally, the complaint should be dismissed because UMGR was never served with the complaint. Should the court find that dismissal is not otherwise warranted for the reasons set forth herein, UMGR requests a hearing regarding plaintiff's failure to serve the complaint on UMGR. Alright, so that goes back to the fact that they said Tyrone Blackburn never served them with the complaint, and he's saying he did. He's saying that his server gave the papers to a woman named Diana Ruiz, but they're saying, listen, no Hispanic lady named Diana Ruiz works for our offices. What are you talking about? And to prove their claim, they wrote, plaintiff filed this action on November 23, 2023. The initial complaint indicated that it was a draft to preserve the statute of limitations under the Adult Survivor Survivors Act, and that this case would be amended and refiled within the coming weeks. Plaintiff filed the first amended complaint on March 12, 2024. Plaintiff's counsel filed an affidavit of service on March 22, 2024. This affidavit of service states that on March 14, 2024, at 12:57 p.m. Post Standard Time, a process server served a summons and complaint to a Diana Ruiz in Santa Monica, California. However, Diana Ruiz is not a UMGR Santa Monica office employee, nor is she a person authorized to accept service for UMGR. See Exhibit D. The undersigned counsel for UMGR, McDermott, monitors the docket for the action and discovered that the affidavit of service was filed on March 22, 2024. McDermott alerted UMGR of the filing of the affidavit of service. UMGR has conducted a search into the allegations of service contained in the affidavit and determined that there are no records or other information supporting the sworn statements by the process server indicating that UMGR was served with the complaint. UMGR staff even reviewed surveillance footage from its lobbies on the purported service date, but could not corroborate that the process server ever appeared at the location where the affidavit states service was affected, and that anyone at UMGR accepted any pleading or any other document related to this case from anyone. Alright, so to support their argument that Tyrone Blackburn never served them with the proper paperwork, the attorneys for UMGR included Exhibit D, which is a sworn affidavit from a woman named Carla Miller, who's the Senior Vice President of Business and Legal Affairs and Litigation Counsel over there at UMGR. And she says that after Tyrone Blackburn submitted confirmation to the courts stating that he served them with the paperwork and a woman named Diana Ruiz accepted them from his process server, she did a global directory search and found that no one by that name works at their Santa Monica office. But just to be sure, she also contacted their Vice President of Administrative Services and Facilities at the Santa Monica office, Lon Murphy, to see if he was aware of anyone named Diana Ruiz who was employed at the office. On March 26, 2024, Carla says, Mr. Murphy emailed me confirming that 1, he was not aware of anyone named Diana Ruiz employed at our Santa Monica office, and 2, he had spoken to 2 of the women who work at the entrances of the building and who were present at UMGR's offices during the relevant time on March 14, 2024, Shauna Alfaro and Dina Montiel. Mr. Murphy further confirmed that neither individual reported having received or accepted service of any document on March 14, 2024. In addition, Mr. Murphy advised that he also obtained and reviewed the lobby security camera footage from the 2 entrances from UMGR's Santa Monica office building, where Miss Alfaro and Miss Montiel sit. Mr. Murphy confirmed that he reviewed the footage starting from 1 hour before to 1 hour after the 12:57 p.m. Post Standard Time, the time when the affidavit of service alleged that Mr. Diaz served Diana Ruiz with the complaint. During this review, Mr. Murphy advised that he saw no indication that any letter or document was accepted by any person sitting in either reception area during this 2-hour window on March 14th, 2024. I swear, knowing Tyrone Blackburn's history with some of these cases, I wouldn't be surprised if his process server handed those papers to some chick who's sitting behind the counter at a local bodega down the block from the UMGR building. What he should have done is caught the whole thing on tape, similar to the way that dude did when he was serving Young Miami the other day. My man wasn't playing. My man was like, smile, you're on candid camera. That's how you do it, because there's no way in the world that Young Miami can ever say that she didn't get those papers. Source, can you please show everybody the video of Young Miami getting served with the paperwork for trademark infringement for her song Act Bad?
Bro, my nigga Charlie C actually served Young Miami with this lawsuit. She's supposed to be in this club tonight. So goddamn, about to do it.
Okay, can I come out video? My birthday next week.
It's a bad bitch birthday. Her birthday is next week. So shout out to all the bitches whose birthday is next week.
Absolutely.
Young Miami.
Yes.
Let me get this to you. This will be some gift.
What is it?
What you just say?
From my homeboy Charlie C, you've been served.
Okay.
Listen, she's better than me, because if he'd have tried to serve me, I'd have been like, no speaking of English, no speaking of English. My name's not Sauce. Alright, so back to the case at hand. So UMGR's attorneys have requested to appear before the court at the New York County Courthouse on May 2nd, 2024 at 9:30 a.m. or as soon as possible, which is like 2 weeks from now. So, in 2 weeks, we're going to know something, because if the judge looks at the surveillance footage that Universal Music Group provides and does not see a process server named Robert Diaz delivering the paperwork that Tyrone Blackburn and Robert claim were delivered to some Hispanic chick named Diana Ruiz on March 14th, 2024 at 12:57 p.m., there's going to be a problem. And if UMGR's HR department provides the names of all the people that work in their California Santa Monica office, and there's no one on the staff named Diana Ruiz, there's going to be even more of a problem. And on top of that, if the court does decide to dismiss the case because Tyrone Blackburn made a huge mistake and filed the lawsuit against P. Diddy and Aaron Hall and UMGR using the Adult Survivors Act on behalf of an alleged victim that was not yet an adult, when he should have filed under the Child Survivors Act, then Tyrone Blackburn may go down as one of the biggest screw-ups ever in the history of ever. And it may foreshadow what we can look forward to with regard to the outcomes of the Little Rod case and the case against Christian King Combs, because Tyrone Blackburn is representing all of them. And I can guarantee you, if one of these cases fall, then all of these cases are going to fall like dominoes, because Tyrone Blackburn may be over there fumbling the ball. Let me tell you something. If I was one of Diddy's alleged victims, right, and I was absolutely 100% telling the truth about what Diddy did to me, I'd be over there trying to switch attorneys, because my fear is, even if some of these people are telling the truth, Tyrone Blackburn might blow the case, because this dude seems to be making a whole bunch of mistakes. For example, in this same motion to dismiss, Universal Music Group's attorneys also brought it to the attention of the court that Tyrone Blackburn has a long history of filing lawsuits in the wrong jurisdictions because he fails to do his due diligence and find out the actual addresses of the people that he's pursuing and suing. And when the courts asked Tyrone why he's always getting the addresses wrong, he said that he takes his clients at their words, and he also does a quick follow-up on LexisNexis. I mean, come on, Tyrone. If you intend to go up against Diddy in court, then you're going to have to start doing a little bit more than a few Google searches. Listen, let me know in the comments. If you were suing Diddy, would you use Tyrone Blackburn, or would you go out and find yourself another lawyer? Also, let me know what you think about Universal Music Group asking the courts to dismiss the suit against them with regard to Gardner versus Diddy, because 1, they claim that Tyrone Blackburn filed the suit using the wrong statute. 2, they don't have anything to do with what Diddy and Aaron Hall did after they had dinner with Jodeci. And 3, Tyrone Blackburn failed to serve them with the proper amended paperwork. Let me know what you think about all of that in the comments. And while you're down there leaving a comment, be sure to like and subscribe to the channel and share this video with your friends. Hey yo, thanks for tuning in to Celeb Source, your source for celebrity news. Be sure to like and subscribe to the channel. Peace.